don't think this court has any jurisdiction whatsoever.
I don't see acute risks of public safety. Mr. Witt, your turn.
I just want to elaborate a little bit on Austin's award. He got an award because he was helping the homeless community. He got an award because he was helping the homeless community.
Austin Davis has been offering free food to hungry people for many years. The city of Tempe even gave Austin an award in recognition of his selfless acts. Then one day, seemingly out of nowhere, the city of Tempe shows up and tells Austin he must stop offering free food to hungry people, and they want to sell him a permit to allow him to continue.
His application, he received a denial letter, and then through the process on F allows a request for reconsideration, which was completed by myself, and then another denial was issued there as well, and the grounds for denial were not found within F.
Austin tried to purchase the permit, but was denied because he refused to stop offering free food for 2 months while they thought about granting his permit. Austin believes that if he stopped for even 1 week, the damage caused by someone starving when they could have been fed morally obliges him to make that food available to those that desperately need it.
They said it would take 60 days to review our application, and as you know, it was a little over a month. But they denied our request for the permit because we continued to host picnics during the review process of our application. And they told us we had to stop during the review process, but morally that just wasn't an option because people still need access to these basic human necessities.
Austin was put before a judge this past week, and I cannot understate the importance of the community that showed up to support him. The judge took notice at the beginning and at the end, and it does make a difference.
Arizona versus Austin Davis. Let me begin by acknowledging that this case has particular community interest, and I'm happy to see so many people here in the courtroom. Unfortunately, because of fire code, we can't allow those that are standing in front of the door to remain there. If you can find a place to sit, great. Or I invite you to go down to courtroom 4 where it's more comfortable and you may be able to hear everything that's going on. Unfortunately, you won't be able to see. And you may want to check in a little later. I don't know how long this proceeding will go. I anticipate it will probably go an hour. If some folks leave before then and there's more room, you can come back up. All right? All right. All right. Let me just introduce to everyone the attorneys that are participating. Alan Witt is the prosecutor. He represents the state. Russell Vicente and Mr.
Aronow.
Aronow, I didn't get your first name.
Victor.
Victor, I apologize. Victor Aronow. They are representing Mr. Davis.
Russell Vicente and Victor Aronow are the 2 attorneys defending Austin. If you'd like to help Austin with legal fees, a link to the GoFundMe I created will be in the description. The following is a shortened version of my footage in court, mixed with my footage of the actual events being discussed.
You claim that the complaint is insufficient as a matter of law. You rely on one of the reasons I think that you argue that the law is insufficient because it's under the code section under amusement, and you make the argument that this is not an amusement and therefore doesn't take in the actions that's charged. Is that right? Is that my understanding? I think you cited one of the parties cited Webster's dictionary definition. I looked at Black's Law Dictionary, which also had a definition, or which, among other things, says a pleasurable occupation of the senses, which suggests to me that the action that is alleged to have been illegal here does fit within that definition.
If I may go back to the Black's Law Dictionary.
Sure.
Pleasurable occupation of the senses is extremely broad and encompassing in the fact that I believe the senses would be in some ways or many ways activated in a public space like a public park. just by mere existence of a person being there? And if not pleasurable occupation, is it painful? Does this call into question, does the definition or what is permitted and not permitted now hinge on whether the food that you're eating is delicious or tastes like tires or is dry cake, is saltines that are unpleasurable?
Yeah.
And that certainly, in my opinion, would detract from using that definition.
So my understanding of your argument is that the term amusement as used in the code is limiting. And you argue that sub F would not be considered, or the prohibitions of activities contemplated under subsection F would not be considered an amusement, and therefore it should not be applied under section 5-2. Is that your argument?
No, Your Honor. So the argument is that because F is a subsection of 1 and a subsection of A, which is a subsection of 5-2,
right,
which is a subsection of 5, that is where the boundaries are drawn such that everything included is amusements. I'm using the term amusements. In the state's response, they said it was diversions of interest, perhaps. When we're talking about things that are entertaining, amusing, pleasurable, things of that nature, it's a diversion from that which is required to sustain life, that which is absolutely necessary for survival. And that would include food, water, shelter from the elements, whether that's a roof or clothing. And so, even going to work, going to our jobs to earn money is not necessarily amusing. Depending on if you're a clown, it could be amusing. But for other jobs, it's a necessity so that you can pay your rent or your mortgage or buy food. It becomes a requirement. Whereas diversions of interest, things that are entertaining, is what you can do with your free time, your excess time. And so that concept is Chapter 5, and that concept begins at Section 5-2A or 5-2. And so the subsection of 5-2F, activities open to the public, activities still refers to the category in the larger section that is these diversions of interest or amusements.
Judge Kane will present hypothetical situations to determine at what point the defense would be in favor of a permit for using a park. A hypothetical question I would have liked to have heard asked would be to take the food out of the equation and imagine Austin is just giving away water. What would be the difference? Would we still be spending taxpayer dollars to prosecute him if he were only giving away water?
Right. So I think you tried to provide some examples, some hypotheticals of activities in a public setting that would be under the interpretation that the city's giving the statute constitutionally impermissible. And we're going to get into the vagueness issues later. But would you agree, for example, in your argument that D should not be included under amusements, that you could, for example, envision, just as another hypothetical, say a high school reunion being planned for a city park, and at that high school reunion, it's in a public setting, there would be perhaps a sale of some merchandise, maybe, I don't know, yearbooks, maybe class rings, whatever it could be that they might want to sell at a high school reunion. That, under D, would require a permit under, I think, the clear meaning of the words, and even by your argument. Do you agree? And would you find that abhorrent to our community standards to require a permit for that?
If I'm understanding correctly, that the sale of yearbooks or even food at a reunion, at a high school reunion, college reunion, held at the city park, would, under my definition, require a permit. Is that?
No, I believe, my belief is, under the plain language, it would require a permit. Do you agree?
When it comes to the sale of food, if there is the sale of food at that event, and I'll jump right to food versus other items, the sale of food changes the nature of the food from something that is essential to something that creates profit or something beyond the bare essentials of survival. And so there is, to me, a large distinction between sharing food freely, as we do with friends, family, we break bread, with commodifying food and therefore selling it.
My point is, under D, there may be sales offered in a public setting, but since the public is not, it's not open to the public, if it's a high school reunion, theoretically, would still require a permit. And the modifying language is the fact that they're selling something, even though it's not open to the public, theoretically, right?
Correct.
Okay. So when you talk about essential needs, such as food to survive, it sounds to me like your argument is because it's a necessity, the city has to allow it without a permit in the park. Whereas those necessities could be provided in other locations, could they not?
They could be provided in other locations. There is question of the need for a permit to do that at those locations because of deviation of intended use of the property. If a church is for worship, does that include food? Especially if food is served outdoors on the patio or in the parking lot. Public parks, especially, as the land granted for everyone's use, it's the oldest, most traditional place for people to gather and freely commune and assemble. And so to limit, I'm not saying that the permit, should not allow folks to bring food into the public court, the courthouse, which is, owned by the people, but the public park as the most base, quintessential, traditional space for gathering and breaking bread and things of that nature with, private individuals or open to the public, I feel it has merit.
So I appreciate that point. Let me ask you this then. If Mr. Davis plans a food sharing activity in a particular park, but that park has already been reserved by someone else, is that something he would check on ahead of time?
He certainly would have the option to check. He would have the option to roll up at the time that he wants to have his, to share food with people and to see that the park is already taken or the ramada that he was most interested in is already taken. Just like any other individual, he can make a choice to find a different location, choose a different picnic table, postpone it to another day, anything of that nature. And if he were to say, well, I don't have a reservation, but I come every Sunday and I want this picnic table, then you run into issues of, assault or disorderly conduct, things of that nature, which clearly have narrowly tailored remedies.
Mr. Witt, your turn. Let me start with a question. Can you articulate what you believe the factual basis for probable cause would be under the complaint? Do you understand the question?
No.
We will talk about all the other things this prosecutor doesn't know a little later. But one of the things I'm sure he doesn't know is what the park actually looks like after some of Austin's private food sharing. This is me investigating the claims of trash and needles left in the park. It could be argued that this park is cleaner on days Austin is there than it is on days he is not.
I'm walking through the park where there was a supposed mass migration of people trying to get fed. And I don't see any trash or needles or anything of that sort anywhere I've been around, everywhere that they've been eating. They've been cleaning up after themselves, and they've been very respectful and cordial with everyone around using the park. So as you can see, a very clean park after most of the feeding has already taken place. It's not destroyed. It's not overcrowded. It's not dangerous. It's not dirty. From what I can tell, the claims about them leaving a litter of trash in their wake are unfounded. This looks like a clean...
Related to the charge was in fact a public event. Mr. Vicente, do you disagree with that?
Yes.
And in what way?
That this event is not open to the public. That it is a event that is closed to a certain community, which is consistently referenced by Casey Hugs and Austin Davis as our community, referring to unhoused and unsheltered folks alone.
Let me back up, and I appreciate you answering. First of all, not only does it have to be an event open to the public, it has to be a public gathering. Do you agree that this would be a public gathering that we're talking about?
Is that the same as a gathering in public spaces?
I think so. I mean, that would be the plain language interpretation I would intend to give it. But that's part of the ordinance. It must be an outdoor public gathering. Under F, it must be activities that are open to the public. I understand we dispute that the activity is open to the public here, but do you dispute that this would be a public gathering?
So if I'm understanding the definitions, any gathering in a public park would be both. It would be a gathering that is in fact outdoors and is in fact in public. Is that
yes?
Then yes, this is
okay,
an outdoor public gathering.
So we can agree on that, and then we can talk more about whether this is open to the public. But you're representing that AZ Hugs limits those that participate in these food sharing events?
Yes.
Okay, because that has not been alleged before. Even you have not alleged that.
Correct. For our motion, our 16.4 motion, we stipulated, or we alleged, we gave facts for the purpose of that argument only, arguendo.
Right, I understand that.
And so we're not stating that those are the true facts from the dates in question.
Sure.
But only for the sake of arguing the language of the statute and its interpretation.
And I see that Mr. Witt is ready to address my question, but before he does, since we've gone back to some of the factual allegations for purposes of the rule only, you do say in your pleading, Mr. Vicente, that AZ Hugs Sunday family picnics involve food, allow for socialization, and incidentally allow individuals at point of contact to connect with a variety of support services. Are you saying that those facts are not true in general?
I believe those are
Or
generally
need to be proven?
correct.
Okay. Because it seems to me that if, in fact, it's proven that the food sharing events allow for socialization, that too would be an event that would be considered an amusement, wouldn't it?
I cannot think of an event that does not involve socialization or communication between people.
But just to provide for probable cause that this activity was open to the public, there was no indicia that these activities were in any way closed off to other members of the public, that anybody approaching would have been turned away. And there's no incident of that I'm aware of.
By saying that it limits those that can participate, that sounds to me like you're saying that it's not open to the public. Is that a fair interpretation of your argument?
Yes, sure.
What conduct does the code sweep in that you feel is constitutionally protected?
So because the code is for any outdoor public gathering using city-owned properties, which we've said is essentially showing up at the public park, that
and open to the public.
Well, yes, and so part parts 3 and 4 from the state's response involves activities, any activity open to the public. And so that incorporates one person wishing to make any political statement, read the Declaration of Independence, read the Emancipation Proclamation, in which they are inviting the public to listen, which is primarily the focus of any First Amendment speech, is to reach the largest audience possible and reach people who are not already in the know and on your political side. And so that is by being anything open to the public, any singing, dancing, pamphleting, any sort of communicative endeavor in which you're trying to talk and reach someone else is more often than not, perhaps by a lot, open to the public. And so this law would sweep almost, I believe it would be shorter to list the items that are not, within free speech.
But would you agree that the litany of case law supports the notion that even First Amendment rights that are fundamental can be subject to time, place, and manner prior restrictions?
Yes, sir.
And isn't that what we're talking about here with the requirement of the permit?
Yes, they have to be.
And that's assuming this is a First Amendment issue.
Correct. So time, place, and manner must be content neutral, narrowly tailored to serve a significant government interest, and leave open ample alternative channels of expression. And that has not only been used for cases directly related to free speech, but to permitting at large, where, as in this case, free speech is so heavily implicated. If I can back up to enforce that point, the state uses, and forgive me because my reply brief is, I believe the deadline is tomorrow, and I have it here, but I have not submitted it.
That's okay.
And
I can be flexible on time.
Appreciate it, Your Honor. The Hicks case is cited that it's a relation, that it's First Amendment activity that may be covered or is covered is enveloped, but in relation to non-expressive activity, that is the main goal of the law. And Hicks, that's half of what Hicks says, and the other half in the same sentence says, or in the absolute sense. And so here, because it encompasses so much, the vast majority of free speech, would require a permit here, that it is directly related. And so the O'Brien test would apply. And so then it does require narrow tailoring to a significant government interest. And courts all across the country have struck down laws that fail the narrowly tailored prong because they have no minimum size limit. Up to at least one case, but possibly more, I don't recall, that even a 50 people, requiring a permit for 50 people is not narrowly tailored enough. And the case that is most on point as far as analogous or similar language would be Grossman versus the City of Portland, I believe, which I have a copy of. It's for you.
Is that cited?
Very long.
Is that cited in your?
It would be my reply.
In your reply, okay, that would be helpful to me, because the cases that you were citing in your other pleadings all seem to clearly involve First Amendment free speech issues, even the parade case, and protected classes. In addition, can you help me understand where food sharing here is a free speech issue or a First Amendment issue?
I think I can help you out there, Judge. The First Amendment of the United States Constitution guarantees the right of freedom of speech and expression, which includes the freedom to engage in charitable activities and express compassion towards those in need. Feeding the homeless is a form of expression that communicates empathy and solidarity with that group.
It's honestly more of a right to assemble issue, and this is why I brought up the standing requirement.
Do you take the position that freedom to assembly issue requires the same strict scrutiny, or not with respect to prior constraints?
I believe that in the original motion quoted a case that does essentially say it's analogous as far as its requirement.
Can you point that to me, please? And if you can't, that's fine. You can include it in your reply brief there. I know you cite Najak.
That's from the 16.4B.
Right.
Yeah.
That's fine.
If
I can't find it, or if you do find it before we adjourn here, that would be helpful to me to be able to focus on that. Is there any other points you want to think out of the overbreadth motion, Mr. So?
Simply that the terms used, I'll include more in my reply, including that quote I could not find. But there's essentially no coming back from a permit requirement for, especially a public park being one of the most protected spaces for speech and assembly that allows that requires a permit for as few as one individual. That's just appears to be the nature of overbreadth as it relates to this.
And help me understand a scenario where the current ordinance would require a permit for one individual if it's open to the public.
If the speaker or the person with more food than they can eat themselves wishes to offer that speech or food to another person, they are now conducting an activity that is open to the public in the public park.
How would you help the court define what would be considered open to the public? Because that's another area where I'm struggling with respect to definition. Would you agree that AZ Hugs advertises their events?
I don't believe so. I believe that AZ Hugs in social media and other places, word of mouth, whatnot, speaks of their past events and not advertising future events, not inviting the public to future events as an open to the public. If they are inviting people to their family or to become members of AZ Hugs, that is not related to the event itself. That's related to membership in the family or membership in the organization.
For an event to be considered open to the public, there would have to be some sort of advertising. Do you think that's a necessary component to determine if something is open to the public? If you have a thought.
I don't know how it would be conveyed that it's open to the public without such language, whether it's on social media or elsewhere.
And you've already said here today, and I think it wasn't made clear in your pleadings, but your position is that the food sharing that is conducted by AZ Hugs and the defendant are not open to the public?
Correct. Okay. And I would add that something may be construed as open to the public such that, oh, I see that this event happens every Sunday. I'm going to go down and hang out or join, and then potentially be rejected. Oh, we do hold this. We are here every Sunday, but this is not open to the public.
Okay, so you're saying that happens?
I believe so.
Okay.
Going back to defining open to the public.
The issue of public versus private appears to be a significant factor in court, but on the street, cops will knowingly lie to you and misrepresent the law or ordinance they claim to be enforcing.
Private parties or not, I'm still seeing people walk in from all over the place.
Well, this is a private event. We're doing a
It
private.
doesn't matter, private or public, right?
No, this is a private birthday party.
There's more than 10 people. We've been watching for about 45 minutes.
That was taken before they decided to have security guards walk around taking pictures of random people and put up a camera tower to watch everyone's actions so they can punish one person.
That's something I think both of us are going to need to look into a little bit more. So I might go back on this, but my understanding, just reading it, is that open to the public is the invitation of participation from the public. It's not an audience that walks around. It's when somebody is participating. But then we get back into semantics of, okay, well, it's like actively listening, participating, which is why I would like more time to look into this and how it works.
Well, that would be helpful to court.
Mr. Davis's permit, there are the denial letters, and the denial...
Judge, I'm sorry, I just have to object because we're getting into facts and state would contend they were never denied or even completed. So I don't know if that's something we want to go into right now.
What do you mean by completed?
So in order for a permit to be denied...
Letters from deputy city managers, right?
Both letters were asking for a permit, and the permit was never completed. It couldn't even get processed by the special events who reached out, and I have emails and all sorts of...
Right, but I think Mr. Vicente in his pleading contested those facts as you represent them. Am I wrong?
Correct.
I'm right.
You're right.
I'm right. Correct. I'm wrong.
Oh, I'm sorry. I did include exhibits of letters of denial from city managers. Not, I believe the state included letters of requesting that Mr. Davis get a permit.
Okay.
Upon his application, he received a denial letter, and then through the process on F allows a request for reconsideration, which was completed by myself, and then another denial was issued there as well. And the grounds for denial were not found within F, and that was explicitly stated in my letter for reconsideration.
So, with respect to your objection, Mr. Wick, this is oral argument. I will put whatever weight I feel is appropriate on the claims of factual basis. But I, in general, as I said at the bench conference, don't find those disputes on the facts to be material. But this specific provision in the ordinance is selectively prosecuted. But am I right about that? You mentioned that.
Yeah.
But do you agree that it's consistently applied to all groups, and there are other groups that do conduct food sharing in the parks, right?
I'm not sure that that's true. And even Mr. Davis was allowed by the city to operate without a permit and awarded as such for years. And so that, in Mr. Davis's case alone, appears to be selected.
So let me just turn to Mr. Wick. Mr. Wick, are you aware, are there other organizations that food sharing that have obtained permits?
Yes, Judge. In fact, one of them, my understanding is because they do it so regularly, rather than having to get a permit for each separate event, they get them for 6 months at a time because they've shown that their willingness to comply. I would need to have my witness up here to testify to the specifics, but that's just one example that we discussed.
Well, given that example, if true, Mr. Vicente, would you agree that at least with respect to similar situated organizations, the ordinance is applied equally?
I believe to make that statement, I would require more than one example where it was also applied.
Yes, Judge, just if I could,
Sure.
Sorry, briefly, just going to what was just mentioned, I just want to elaborate a little bit on Austin's award. He got an award because he was helping the homeless community.
I just want to elaborate a little bit on Austin's award. He got an award because he was helping the homeless community. He got an award. He got an award because helping the homeless community. Was helping the homeless community.
I don't think this court has any jurisdiction whatsoever. There are other remedies which might be available to the state, but the writ of prohibition or the special action is not one of them.
Appreciate that, Mr. Aronow. All right. And then the final motion from the state is a motion to impose conditions of release. And let me just point out that my understanding is there was never a booking, there was never an order setting conditions of release to this point. Standard conditions of release that are required if I impose conditions of release would be that the defendant must not commit any criminal offense. So how would that be different than what the state is asking?
It's not different in effect, and that's why I filed them both, because I wasn't able to find solid ground.
These are the excuses you would expect a first-year law student to use, but this is not a law student. This is a city prosecutor, filing 2 motions just to see if it would work, as he mentions in court, leads me to believe he is potentially attempting to play on the judge's lack of knowledge. Thankfully, Judge Kane isn't as ignorant as the prosecutor had hoped, and his feeble attempt to sneak one by was properly shot down.
The special action, except that it was typically for review, but how do you review a decision that hasn't been made? Even though they're disputing whether or not this law is constitutional, their continued violation of it is, right now, it's not legal. Well, he's presumed innocent, the law is presumed valid. And right now, the law, he's continuing to do the facts that meet the elements. Now, if those elements end up being unconstitutional, then we would go from there, I would think. But everything would be stayed in the meantime.
Does that not put the court in a position of making judgments regarding probable cause that are typically reserved for law enforcement? There are other mechanisms, are there not, for the state to accomplish what you're asking the court to do without undue involvement in the court in deciding whether the conditions are met or not?
Yes, Judge. I believe that there may be other mechanisms out there. However, as on the prosecution side, criminal side, these are the only 2 mechanisms that we were able to discover to enforce this through the criminal courts. But there may be other remedies.
Okay, I appreciate that. Thanks for answering those questions. Mr. Casenti, do you have any statements to make with respect to the state's 2 motions, the one for, in addition to what's already been said regarding the release condition request and the prohibition?
Your Honor, you already asked most of the questions that I would have brought up for you to decide.
I don't see acute risks of public safety. I understand the claims that the state, the city is making regarding how it does affect the community at large, and I'm not discounting that at all. There are valid points and valid concerns on the issues that are really before the court on both sides, and I appreciate the public interest. And that's why I want to make sure I make the right decisions. And ultimately, I suspect that whatever decision I make, someone else above me is going to review it. And that's okay too. That's why they're there. You see an opening maybe 3 weeks out where we can hold an evidentiary hearing?
June 13th at 1:30.
Thank you all for your interest in this proceeding, and you're welcome to come back for the next one. So thank you all for being here. Court is in recess.
For more details, check the description section under this video. Like and subscribe to stay updated on further developments.